All right. Well, welcome, everyone. Good morning. The first panel today is on the subject of collecting and reviewing data and the challenges that it presents and how we're going to streamline the process. The entire day will be, or the morning, I should say, is going to be devoted to this evaluation of the collection, review, and analysis of data in the context of internal investigations. Now, those of you who were at the panel last year, remember we were talking primarily in the litigation context. Today we're focusing on internal investigations, and I think many of the examples, the anecdotes that will be coming out during the conversation today really will illuminate what is becoming a very rapidly growing field. And just to review this, I mean, certainly as a general counsel, I'm very much aware of the really striking trend within corporate legal departments today of the amount of time that internal investigations and compliance activities generally are consuming within a legal department. I've had general counsel say to me that it represents in what they're doing the majority of their department's work. Now, that you may regard as extreme, but the bad news is this is only going to get worse. And maybe it's worth taking just a step backward to get some context about how did we get to this place. And I would kind of place the marker in recent times anyway, back to the development of the organizational sentencing guidelines back in 1990. Now, what that did was it established what was the makings of a corporate compliance program that a corporation could use in its defense in the event it was criminally charged. And it went through the various elements of what I guess I'll say a good or reasonable compliance program consisted of. And that was really setting out the basics. But then in the mid-90s, we had a decision come out of the Chancery Court in Delaware which set the bar for fiduciary standards of directors in terms of what their obligations were in assuring that a corporation had a effective compliance program. And that decision, of course, was the Caremark decision. And it really has affected the activity in this area all the way through to today. So after Caremark, then we had Sarbanes-Oxley, which established quite a number of specific guidelines for corporations, including, of course, the rather infamous provision 307 requiring this reporting up within the legal department and among outside law firms for knowledge of violations of securities laws or other material laws. And we then had directors phoning their counsel and an in-house counsel and asking, what is an effective compliance program? How do we get there? How do you assure that I'm not going to be held liable and I'm going to have to dig into my pocket to pay damages? So corporations began to focus a great deal on compliance programs, and now with the advent of Dodd-Frank in 2010, and in particular the whistleblower provisions and the bounties that are available now to whistleblowers for identifying or at least the allegations of wrongdoing, misconduct, violation of the company's own compliance programs, the opportunities for internal investigations abound. And as you have all these whistleblower reports, hotline reports, and the like, what is a general counsel to do? It's something that I actually have pondered a great deal about because when you think about this, compliance programs exist in so many different areas of the company. As allegations arise of violations or of wrongdoing, you really cannot afford not to investigate anything. I mean, you have to investigate everything, at least in a triage sense, to figure out if there's any wood behind the arrow. You need to at least take a look at it. So there is an internal investigation of some magnitude for almost all of these allegations. But the real problem is sorting out what's what. And last night I just put together a very quick list. I was thinking about what compliance programs, what type of compliance programs are we talking about? And the list is very long. I'm going to read a few of these, and I think you'll start to see how extensive this problem can be. So what are the types of compliance programs? Anti-bribery and anti-corruption, conflicts of interest, antitrust and anti-competition issues, data privacy, IP enforcement, export control, money laundering, human rights, environmental compliance policies, health and safety, supply chain issues, child labor, conflict minerals, working conditions. Those are pretty nettlesome. Securities law compliance and the whole area of insider trading and the like. Those are just a few, and you can see this is so extensive that it is quite likely that you're going to get allegations coming in bushels of some of these policies, and that's a good thing. So here we have today, fortunately, a panel that's going to enlighten us on how you proceed with the mandatory internal investigations of some of the topics that I've talked about. So let me introduce our panel that is going to help us understand all this. First of all, I'm going to start way on my right here, on the far right, and then come down the chain here. Troy Dunham. And Troy, as all of the people are here on the panel, is an attorney, and he is with Discovia. He's the Vice President of Client Services for Discovia, and he's responsible for the structuring and overseeing of large-scale engagements and enterprise account relationships for the company. He also serves as Discovia's expert in the areas of information management, data identification, preservation planning, and meet and confer preparation. He has focused his career on eDiscovery since 1999, and prior to Discovia, he was the Senior Electronic Discovery Manager for the Cooley firm. So thank you, Troy, for joining us. To Troy's left is Lynn Ager, and Lynn is with the Kasowitz firm, and had a long drive this morning from Marin. And as I think those of you who battled the traffic locally realize that was pretty grueling. Lynn's practice focuses on federal and state white-collar criminal defense, and she's represented and assisted in the representation of major corporations and individual targets and witnesses in a wide range of criminal cases, including fraud, antitrust, securities, insurance, tax, healthcare, maritime, environmental, and public corruption. Again, a long laundry list. And she's tried quite a number of felony cases before juries during her long and distinguished career. So welcome to you as well, Lynn. Then to Lynn's left is Deanna Slocum. And Deanna is a like-minded corporate set from the corporate world. And battling these problems from an in-house perspective. She is the Vice President of Ethics and Compliance at VMware's global headquarters in Palo Alto. VMware, as you may know, is the leader in virtualization and cloud infrastructure solutions, and a very important player today as we move into the cloud era. Prior to her current role at VMware, Deanna was the head of compliance for the largest of three Siemens AG business sectors in the United States, the United States industry sector with more than 40,000 employees and $12 billion in revenue. And previous to her role as head of compliance for Siemens, Deanna led the license compliance and anti-piracy enforcement efforts in Europe, the Middle East, and Africa for Adobe and Macromedia. So thank you, Deanna, for joining us. And then finally, to Deanna's left and to my right is Joe Lee. And Joe is a litigation partner in the Los Angeles office of Munger, Tolles, and Olson, and his practice focuses on complex civil litigation and white-collar investigations. He's litigated a wide variety of complex litigation matters, including consumer class actions, False Claims Act litigation, securities and antitrust cases. And Joe's argued cases before the U.S. Court of Appeal in the Ninth Circuit, the Court of Appeal of California, and the Judicial Panel on multi-district litigation. Let me just go over a couple of logistical points, and then we'll get started. First is that the opinions of the panelists are their own opinions. They don't represent necessarily the views of their firm.
In my case, they almost certainly don't.
Fair point. We'll try to run this for the better part of the time allotted. But if any of you have questions, rather than holding them back and then trying to remember at the end what you were going to ask about, raise your hand and I will call on you. I think we have a microphone that we can provide to you. If we have too many questions, we'll save some for the end, but I would like to make this a little bit more interactive. So as questions occur to you, please feel free to chime in. Okay, well, with all of those details out of the way, why don't we dive right in? So again, our topic is on the collection and review of data in this panel. So why don't we start by talking about current trends? And let me throw out questions to the panel and ask you all to comment as you wish and add your own insights and examples from your own experience. Let me start by asking the questions, what are the trends that you're seeing right now in your own businesses or your practice areas in internal investigations, both at a high level, kind of an overall volume level, but then particularly by type of investigation and activity? Troy, you want to start us off?
I'll start. And coming, of course, from a service provider perspective, I'm looking at the mechanics of the collection and the review, where the rubber hits the road. And for our company, we've seen a exponential growth. I think 3 years ago, I'm looking at Chris down here, who's he heads up our compliance, ethics, and investigations team internally. We probably had 10 investigations. 2 years ago, we probably had 50. This year, we're well over 100. So each year, we're seeing at least a doubling, maybe more, probably 10 times what we saw 3 years ago.
I would agree with that, especially, Dodd-Frank has changed everything for us, I think, from an internal perspective. But the good side of that, there's a lot of volume, but I'm seeing, at least in our business, that the substantiation rate is going up, which if you benchmark against similarly situated companies in high tech especially, if you look like the Corporate Executive Board does great benchmarking studies on this stuff, and they estimate that the substantiation rate is 30 to 40% max. I'm starting to see that number creep up, and I question whether it's because the Dodd-Frank, the publication that we are doing around our whistleblowing, around our hotline, making it comfortable for people to come forward. It's creating much better data, much better facts. They're bringing forward information that's truly unique and important for us to look into.
I come at it from a completely different perspective, because when you call me, you've usually had a knock on the door by either the FBI or some other agency or received a government subpoena. So our internal investigation activity is usually generated by government activity. This year we see a large increase in antitrust in certain areas, different types of corporate fraud, Foreign Corrupt Practices Act. Whatever agency or whatever investigations are moving forward at a fast pace really triggers the type of internal investigation work we become involved in.
I'm at Munger Tools down in L.A., as was mentioned, and my experience is somewhat different from that. I think most of the investigations, looking back, that I've worked on in the past few years have been triggered by either an internal audit review or an anonymous complaint from an employee. And one of the key decisions we have to make is, are we going to make a voluntary disclosure to law enforcement of the results of the investigation, which is a really troubling and nettlesome question. Obviously, there are some contexts in which there's a legal duty to make a disclosure, such as the False Claims Act, but most situations, antitrust, FCPA, do not have such an obligation. And there's some fascinating literature about in the FCPA area that many of you may know that suggests that although the DOJ and SEC tell you that you will get substantial cooperation credit if you voluntarily disclose, if you analyze the amount of the fines and penalties that are paid in voluntary disclosure cases versus non-voluntary disclosure cases, the average fine and penalty, at least by one metric, is higher when companies have self-disclosed. Now, maybe that's because you tend to self-disclose in the really bad cases, but you got to take, I think, with a little bit of a grain of salt, this cooperation credit that the DOJ and SEC are promising. So I find that we struggle a lot with that. God, I'm going on at length, but I tend to do that. The main trend that I've seen on internal investigations, and maybe it's a result of how much they're growing in number, is I'm finding more and more of my clients want to do the document collection and maybe the review in-house. So they're hiring and they're training forensic departments, computer forensic departments that will do the collections and may even staff up and conduct the review. And that presents some challenges for outside law firms because we want to be sure it's being done right. And sometimes the in-house guys don't have quite the same level of expertise as the firms such as Discovia or Epic or their competition in knowing how to create a chain of custody and making sure you're getting a true forensic image that permits you to restore double deleted data. And so I frankly get a little nervous around the lack of control about that. But I've seen that at several of our larger clients.
I'm going to follow up on that, Joe, because that's an interesting point. And actually asked Deanna this question because you talk about in internal investigations how common it is for corporations to turn to their internal resources for help in developing the record, if you will. And I assume that you're contrasting that with the situation in litigation where maybe they turn it over to outside counsel and outside firms to develop the record and do the review. So, Deanna, I wanted to ask you, from the in-house perspective, do you treat internal investigations differently from a record collection perspective than you do ordinary litigation, and if so, how?
Well, we try to, obviously. I think, to Joe's point, companies do have to bring this more in-house. The costs with an external resource collecting and reviewing data are crazy. We try to budget every quarter, every year, and our finance people just keep wiping their heads when they come talk to us because they're like, you guys, you're just not even predictable at this point. So we do have to have some level of predictability with how we're accruing and accounting for those funds. And so with that, we bring them in-house to try to control the investigation creep, if you will. And with that, distinguishing between the types of investigations that you're going to use external resources and those that you're going to use internal resources for is very much different. And I think every company goes through that process. So in my case, we have sort of a small difference, I would say, between what we do internally and what we would prepare for external review. I always tell my team that know that anything that you produce, anything you put in writing could see the light of day at some point. So be careful, in terms of keep it factual, keep it, reduce the conjecture and opinion as much as you can. But we do try to, if it's something that we have the expectation that it could see the light of day, more probable than not, if you will, we definitely try to cloak it in privilege as much as we can. But that's not always possible because we don't have a ton of lawyers that can oversee our investigators. And as I was explaining to Dan, it's not just investigations team. For example, in my group, I manage investigations, privacy, as well as trade compliance. So I have a regulatory component as well as a investigation side. And in our team, I don't have many lawyers. Most of my team are professionals in their function, but they're not lawyers. So they don't have privilege that comes with what they're doing. And that's pretty standard, at least from what I've seen in the industry on the investigation side of the house. So I would say we do treat things differently. We try to, as much as possible, cloak things in privilege, but where we can't, we just make sure that our data collection processes on the data privacy side are rigid and locked down. And then we also make sure that we are careful with how we're collecting the data and how we're reporting it out.
If I can just leap in on the privilege point, I get that question a lot, whether we want the investigation to be privileged, and if we do, and My instinct is usually yes, because you never know how it's going to come out, right? And then also, what if I have non-lawyers conduct the investigation, and how can I get the privilege? And the usual advice I give in that situation is a lawyer can conduct or supervise the investigation, but can use non-lawyers to actually conduct it. And so you send what's called an upjohn letter to the investigators. They could be forensic accountants, they could be HR personnel, but you basically document the fact that you've been retained to provide legal advice to the client, and you are retaining them to assist you in fact gathering necessary or requisite to providing that legal advice. You send them that in a document typically called an upjohn letter, and then there's at least an argument, and I think actually a pretty good argument, that when they go out and they fact gather, even if they're doing interviews, although they're non-lawyers, that nonetheless, because their work is done at the behest of counsel, it falls within the scope of the privilege.
Well, and that's true for, I think, primarily U.S. investigations, but for those of us who are multinationals, and 60 to 70% of what we're investigating are outside of the borders, privilege is a very different concept, and lawyers don't necessarily, in-house lawyers don't carry privilege, so you really have to have external counsel, and that's a completely different genre of
No, that's a good point. Joe, let me follow up on what you're saying. I mean, I wonder, again, we're talking about internal investigations, not in the litigation context now. And we're talking about a corporation, a large corporation, let's say, that's receiving hundreds and hundreds of allegations of wrongdoing in its hotline or through whistleblowers. How realistic is it really to ask that a lawyer be in charge of every one of those investigations? I mean, do you realize the cost that imposes on a corporation? I understand from outside counsel's view that would be the recommendation. It would be mine. It has been mine as an outside counsel. But I'm just saying the reality is there aren't enough hands on deck to really do that. And this is the tidal wave that's about to sweep through large corporations. With all of these allegations of wrongdoing in compliance programs, I don't know that you have any solution really that's workable other than what Deanna was saying, to have a team of people, not lawyers, but people who are really professional investigators, whether they're in the IT department, the HR department, the internal audit department, that they would be the people who are on the ground really having first-line responsibility for the investigation. And then at some point, based on training from the legal department, they would get the legal department involved. But I really don't think that it's practical to operate with a paradigm that lawyers, have to be involved in every instance as supervising the investigation.
Well, and another point, which I would open this up to the audience, in terms of the types of investigations you're seeing, I know in my businesses, in the companies I've worked for, 70% of what we see are employee misconduct. Allegations around employee misconduct. So you're not necessarily going to bring an external counsel in for that unless you're dealing with an EOC claim or something that could potentially turn into a harassment civil litigation matter, which absolutely.
And to that point, and you brought it up before, the most effective method of dealing with the spectrum of litigations. If you think about the list that Dan said at the beginning, each of those carries a different duty and a different approach, and whether they're international, whether they're U.S. based, and what we've seen achieve what I think is the highest level of efficiency is having a set approach to each of those different types of investigations, and having an approach that you follow each time. Some of them the most efficient way is to handle them in-house. And for some, where you may have multiple attorneys coming in from different areas to review the documents, that might be a place that you need the help of a service provider but it doesn't have to be a one-size-fits-all for all of the different litigation or investigations.
Well, and also I think another paradigm to look at is that many of us now in the compliance function, we either report into or are closely aligned with our litigation team. So we actually share resources. So it's also I spend quite a bit of time educating my litigation team and even my general counsel about how we would want to handle certain types of cases based on the nature of the case. You know, we have a very specific grid. That grid determines who is the deputy that handles that case and what that nature of the role that deputy performs. But in terms of you know, when we add the litigation context into the matter, it's a completely different resource question, and it's a really burdensome one.
Sure, and when you anticipate that at an early stage, it dictates the approach you're going to take all the way through. Even if it turns out to be unsubstantiated, you still end up having to put those systems in place.
Right.
And to the point of counsel's involvement, I didn't mean to suggest that you necessarily want a lawyer on every investigation, although I do think everybody in the room should have a lawyer, and it should be me.
On every case.
So
You'd be very busy.
I'll be very busy. Yeah. I think a company has to have a checklist when an investigation comes in, and there's a series of questions to ask. Do I need to involve counsel in this, or can it be investigated by HR, right, or some other group?
Or internal audit.
Internal audit, right. Internal audit can be a very robust and effective way of conducting an investigation. Do I want it to fall within the scope of privilege or not? Do I need to bring in house counsel? Do I need to bring in outside counsel? And typically, outside counsel are only brought in for the most significant investigations because we're expensive, right? We're not free. And if you bring in outside counsel, you're looking at probably spending a minimum of hundreds of thousands of dollars and maybe millions of dollars, depending on the scope of the investigation. So I think companies wisely choose to bring in outside lawyers only on their most significant problems. But the question of whether you want it done within the scope of the privilege needs to be decided early before really the investigation is conducted, because you can't impose the privilege retroactively.
And the problem with that is that at the outset, when you receive the complaint, you don't know whether it's going to be the kind of investigation that is going to require privilege and bringing in the heavy artillery through outside counsel. You just don't know. So you have to do some investigation to even determine whether this, is a bread box or a telephone booth. I mean, just to size the thing, and that's the hard part. So. Troy, let me ask you for your perspective on what you would consider as companies begin their compliance investigations, pain points. What are some of the real difficulties that companies encounter as they think about the process of collecting and reviewing data?
There are two major pain points that I see companies encounter. The first one, we've touched on it, is collection. And we've talked about the substantive legal issues around it, but also there's the mechanical issues around how to perform collections, often in international locations, and often, especially if you're talking about things like FCPA, perhaps remote salespeople that don't have an office, don't have at least a...
Well, and your privacy issues
That's right.
are enormous.
That's exactly right. And so collection, certainly. And that's not even, we haven't even touched on the mechanics of it and the repeatability of it, and whether or not you try to use internal resources or that you use a service provider. And then how important and to what extent do you want to maintain chain of custody, and to what extent do you want to do, as Joseph mentioned, a forensic analysis. And that speaks back to that having a template in place, a game plan that you follow in each of those. So the first one is collection. The second one is then there's a contrast between litigations and investigations. We've talked about that. And in litigations, you tend to look for the haystack in the field, the documents or things that tend to show or tend to prove your side of the argument. In an investigation, you're really looking for that needle in the haystack, or the few needles in the haystack. And so it's a different mindset on the approach, and that takes different tools. It takes a different type of reviewer, and it takes a different approach to how you winnow down those documents, because the collection isn't any smaller than in a litigation, but the substantive documents that you end up using tend to be much smaller, on the order of 0.1% or 0.01% of what was originally collected, where in a litigation you might produce 10 to 30% of what you collected. And so you have to have a different approach to how that's done. And it's not that it's hard if you have a template in place, it's just a different mindset for many folks who came up through a litigation rank and now find themselves working on investigations.
And there's I think that the other factor to consider is your record retention policy.
That's right.
So, for example, this is the interesting sort of differentiation between a compliance person and a litigation person. And I can't speak for litigation other than what I've heard, but from a compliance perspective, you want your record retention policy to go for 25 years because you want to be able to discover everything possible. You want to look for every possible needle that's out there, especially if you've got a criminal case. You want to make sure that you know it well before somebody else knows it. On the litigation side, you don't want anything to be retained. You want your record retention policy to be 6 days. And so it's a very difficult conversation to have with the company because you have to sort of gauge which is the best for the company, but you've got so many different types of cases that it's hard to draw that line, if you will.
Well, the other problem is that the kind of employees who observe your retention policy, they're thorough, they're conscientious, and they delete their stuff. They're the ones who are going to have the good documents, and then the ones who don't observe because they're lazy. Well, I've made my point.
Yes.
Troy, what you said is really quite interesting to me, that this difference between the way you approach record collection in internal investigations versus in litigation. Is the cost, because you're looking for the needle in an internal investigation, which is a good way to put it, and it's so specific, so targeted, is the cost of those investigations in terms of the collection of data and so forth and the time required quite a bit less than it is in a typical litigation context?
It's a great question because there was some, and I forget which of the panelists here made the comment about the costs of review and the costs of collection. What we have found is that the costs are actually substantially less than what you would see in a full-blown litigation, and part of that has to do with the fact that you're looking for the needles, not the haystack. Where I would qualify that, though, is that depending, again, on the type of investigation, you might need a full forensic examination of each hard drive that's collected, and you might need a full forensic examination about the data that you collected from things like SharePoint servers or some sort of obscure, if not obscure, at least arcane collections from the standpoint of a forensic analysis. And the next panel, of course, will talk in depth about that. But that's where you could see on a per unit basis, you could see increased costs if you're doing a full forensic analysis as opposed to a litigation where you might not have the same level of forensic in-depth analysis. When it comes to the review side, typically because you've streamlined the tools, we see that the review costs are actually substantially lower because you're narrowing in more effectively on the needles.
Dan, if I could chime in on one of the different points. You mentioned cost, but you also mentioned time. And interestingly, our experience is on the litigation side that there's huge sort of, cost savings potential from having the right process. But the big win on the investigation side, from what we've seen, is actually the time savings, right? So you mentioned having this team of folks that handle the investigations inside of companies. With things like Dodd-Frank, you've often got this kind of deadline hanging over you where you've got to get it done in a certain time period. And a lot of the internal systems that corporations have today to get the data, pull it in using internal IT teams and various different platforms just don't enable those investigators to get through the information faster. So we found that one of the big wins from the process is actually just crunching the time frame to resolution by having a system that either inside counsel or internal investigators or outside counsel can tap into more quickly and get the investigations up and running faster.
And very quickly to that point, one of our recent investigations, and like I said, we're seeing those come in now on a nearly daily basis. One of the recent ones we had, I think the notification came in on a Thursday, the collection took place on a Friday, and the team was on the ground doing interviews with the reviewed documents on Monday.
One of the things I find helpful, and it's kind of changed over the years, is before I was telling someone we used to get a group of documents, look at them, and then kind of decide what the case is about. Now you need to decide what the case is about before you start looking at the documents. And so to get your inside counsel, outside counsel, your key players together and really try to identify the issues will help you streamline the process of the collection and then review. And using the correct tools to do that can really help minimize a company's time and expense and focus the attorneys more on what you need them to focus on instead of dealing with a lot of external documents that aren't useful to your investigation.
I'm actually curious from especially from the Discovia team, but also from outside counsel. One of the things that I think we grapple with as a cloud company and many companies today is the BYOD, right? So you're bringing your own device, which could be your laptop, it could be your cell phone, any number of devices that connect to the network. And obviously, if they connect to the network, there's a central service point that you can grab the data. But what if you can't? How do you pull all that data together to make a comprehensive story?
It's a great question, and that's partly why I said that one of the biggest pain points is that collection. BYOD is almost universal now. And there's few companies that lock you down to bringing your own device. And so we're constantly implementing new collection methodologies to be able to, cell phones, of course, are the big pain point. Computers, most of the time, we can work with, the encryption can present a problem, especially for former employees. But the cell phones, there's just, as you all see, there's constant upgrades happening. There's constant technology that's coming into the market, and each of those has new gotchas.
Well, and the employee's right to privacy on
Sure.
those devices is of paramount importance. So I would like to ask the audience, do any of you, or have any of you come up with a great solution in trying to obtain the employee's consent to pull data at any point in their tenure or even after their tenure? Did they have to sign when they come in?
We do. It's a policy that we have in place where basically anything that you use, electronic devices, be it your phone or tablet or your own computer, as soon as you touch our data or our networks, then we have the right to access and image and analyze the device. We really haven't had to fight it yet, but the policy is in place and it has not been challenged.
And do you also have operations internationally?
We do.
France and Germany? And they agreed to that?
Agreed.
Yeah.
Well, and Deanna, to that point, right now we're working with one of our clients to conduct a wide-scale test of BYOD collections and collection methodologies, and so it's something I know that national and international companies are facing across the board.
I often ask the question of the audience when I do speak on these panels, because honestly, that is, I think for compliance officers, that is the biggest challenge we face right now, is you've got the intersection between employee privacy and the needs of the company, the compliance needs of the company, and I haven't found a happy medium yet.
Especially for France and Germany.
Yeah, and I mean, I have a guy with a company that we encourage this. We want people to proliferate their devices, and you know, it's
From an investigation standpoint, obviously it's easiest for me if it's a company-issued device and the employees sign an agreement that says that that device is the company property and anything they put on it, the company has a right to see. But often that's not the case, as has been explained.
well, and
I've-
thanks to Snowden,
Yeah.
now employees actually read those statements.
Yeah.
And they don't
And
like
maybe
it.
they resist it,
They do.
but they do want to continue getting a paycheck.
Yeah.
So I've been comfortable in doing collections. If a custodian came to me and said, look, this is my device, I have some business stuff on it, but I've got some personal stuff on it, I've been comfortable doing a targeted collection of just the business stuff. I realize I'm not doing a full forensic image, I can't restore double deleted data, but I'm comfortable going to a prosecutor or a litigator on the other side of the case and saying, look, this individual had privacy interests that I needed to respect, so I did a targeted collection, I documented it, I was thorough in identifying business-related documents on this device, and I collected all of those. And I haven't had a problem yet, I probably will someday, but I think from an investigation standpoint, that's a prudent way to proceed.
But in a statement like that, aren't you opening yourself up to a issue? If you're saying, I'm looking for my business data and I didn't touch the private, well, how do you know between private and business?
Well, you got to have a procedure. Yes, is the answer to your question. Yes, I'm opening myself up to a potential problem. I'm avoiding one problem, which is the privacy rights of the employee. I'm creating another potential one. But you do your best. You have a custodian interview. You have them walk through what files and folders they created. You think of ways to search the balance of the data and collect that. But you're not going to get everything. So you raise a good point.
Let me kind of move to a tangent here, and that is in terms of the types of data. How have you on the panel been able to deal with the different platform issue, texting, text messages, or the use of other private channels of communication, encryption data. I mean, have you seen companies deal with this issue through the policies that it's creating for how employees use their systems, the company systems, as well as their own personal systems, or have you had to handle it just at the review stage and make the best of it?
Well, I've spent a lot of time polling my fellow comrades in this situation. I could say, at least of the companies that I've talked to, where there is a policy that says, if you touch our network, you are acquiescing to our terms, in most cases, the company provides the device. And the employees, they acquiesce to it because the company's providing the device. But where you're encouraging or asking your employees to provide their own devices, that's where I find the policy won't fly.
Well, and in the instance of text messages, for example, it doesn't touch the company's network.
Exactly.
So does that actually fall under the agreement that if you touch the network, we own the data?
I found, because I've seen companies that have found that they've managed to do text messages, and it seems to me it kind of delineates between industries. So more conservative banks, finance, healthcare, more conservative industries tend to have more liberal liberties that they can take with our employees. Ours, forget it. IT, high tech, they will not acquiesce.
I think some of it also comes with education of your employees, because what I see from my end is people who think they're staying off the system by text messaging each other, like, oh, we're going to sell this at this price. What are you going to sell at this price? And they think it's never going to come to light. But the government's wiser than that, so eventually there was a subpoena for that. So to get some information out to the people who work for you about this isn't just company things that can eventually come back to hurt the company. So they have a full understanding of the collection ability.
So it's dealt with in policy, in corporate policy.
We
think
try
that really
where
is,
they'll agree to it.
yeah, is the only way to handle it, because it's so common, Lynn, as you say, in the negotiation of a contract, that you've got the contract on the screen in front of you, but the salespeople are chatting away on texting, while you're on a conference call, and of course that's a fairly rich source of information for a regulator, and it really has to be the corporate rule that's enforced that type of communication isn't permitted outside of the corporate network.
But the fundamental issue, at least in collecting the data, is also what jurisdiction you're in terms of the culture. So there are many cultures, China being the most obvious, that they don't put anything on email because everybody's watching. So they know better. So if you're doing an investigation in China, you're probably not going to find what you need on email. And that's the challenge, is you're collecting all this data, but you're very rarely going to find that needle in the haystack in certain countries where the culture just knows better than to acquiesce.
To sort of contrast with, you talked about the financial industry, and certainly under the SOX, they end up, the chats you've got the chats, so they might be on the phone, they probably have a phone recording as well. And so it's also a different vector to find that they have to keep all the text, they have to keep all the chats.
Let's shift to talk about process and best practice. I was talking at the very outset about the the fairly daunting volume of these internal investigations and how rapidly they're growing, how can corporations handle that volume? I mean, what can they focus on making the process of data collection and data review more efficient in some way? Developing a repeatable process, or we talked earlier about using cross-functional teams and having a set team conduct these. What are some of the ways that corporations can build efficiency into the process so that they can handle this, this tidal wave of compliance investigations? Anybody?
Well, I'll open it up. We try to, at least from my perspective, I feel like email review is another area where employee privacy rights should be taken into consideration, especially if 70% of your investigations or allegations involve employee misconduct. So we're not talking about a regulatory criminal or potentially, deal killer for the company. So we try to wall off the types of investigations that warrant an email review. Because also email review is a cumbersome process, especially if you don't have great tools that can assist you to narrow down the scope of the review. So we have we send all of our investigation requests that involve email review through a centralized process that involves usually one individual who's the custodian of that request. This person is also responsible for obtaining the email and even doing a preliminary word search to see if there's anything that needs to be delved into further. So we do sort of bifurcation when we have a more extensive review. But it definitely is something that we try to hold out for the more serious matters rather than every single investigation.
I can think of 2 or 3 ways to try to control cost and promote efficiency in investigations. One is to limit the number of custodians you collect from. So right now I'm doing a collection, which is probably the biggest I've ever done. We have 250 potential custodians spread around the world. We've identified 90 priority 1 custodians, and we're going to have a dialogue with the investigating agency about who needs to be collected from. Now, 90 is still a huge number, and it's still going to be a ton of data, but it's a lot less than 250. So one thing you can do is reduce the number of custodians from whom you collect, realize, we're going to miss something, but you can't let the perfect be the enemy of the good. And I'm a big fan of transparency and negotiations with the other side, whether it's another law firm in the litigation context or whether it's a government agency that's investigating you, about who we're going to collect from. Let's identify the key custodians, collect their data, review it, produce it, and then if you decide when you review that documents there's some other person out there that you're seeing in the documents, we need his or her data too, then we'll go get it. But we're not going to go get the whole 250. So that's one thing. The other is you can use search strategies that, again, might miss something, but at a significantly reduced cost can get you probably 95% of the key documents. And you should also, of course, consider some of the advanced review processes such as predictive coding, which we've used with pretty good success, I think, in cost reduction as opposed to the more traditional Boolean searches. So you can, and once again, I prefer being transparent with the other side. This is how we're going to tackle this problem. Sometimes you use a mix. Some predictive coding to identify documents in certain categories. And in other contexts or as to other categories of documents where Boolean searching can work to identify the key documents, you do that. So I've done a combination after negotiation with the DOJ, for instance, in a recent criminal investigation. And that can save a lot of time and cost.
Oh, they're all great points, Joe. Great points. Lennon?
We've had great success working with the government in agreeing to search terms, types of predictive coding, and really limiting it, because sometimes what they're asking for could be
everything.
Yeah, I mean, it's when we turn it over, do you
Usually
want
it's asking for
50
everything.
million documents, or do you want 400,000 documents? And then once they realize they're going to need to review it too, or how to review it, usually we can come to some agreement that significantly limits what you start with. And I always say that when you get a government subpoena, that it's the starting point for our negotiations of what we're actually going to produce to them, because they kind of throw it all against the wall, and then you meet with them and narrow it and see what you really want, and you can cut it down significantly through effective negotiation with them.
I second that or third that. In my 15 years working in electronic discovery, I worked on hundreds, maybe thousands of regulatory agency investigations from a discovery standpoint, and sat in on literally hundreds of meet and confers, and every time the regulatory agencies have been amenable to talking about what you're really getting at, without exception. That's been the case. One thing that I have seen, along with the increase of investigations that are coming in, is also a rise in the last probably 5 years or so of the number of in-house electronic discovery support at corporations, and that would be not somebody who's necessarily like a lit support kind of person who's processing the data and that kind of thing, but more that can coordinate the collections, that's aware of the company's stance on privacy matters, for example, or privilege matters, and takes that into account when they coordinate those collections, and then they can coordinate, they can help make a decision about this is going to be a lot of data, we need to work with a service provider, or this is the kind of investigation that stays in-house. I've probably seen what maybe 5 years ago I could name a handful of in-house eDiscovery type of people. Now I was talking to somebody earlier today about I probably get something coming across my desk saying, do you know anybody who might be a fit for this position on a weekly basis? So companies are really moving in that direction. And I encourage them to involve them in the investigation side. Again, I think the mindset has been looking at it from a litigation side. It certainly would be helpful to work with them on
How about the use of offshore resources for data review?
In the investigations realm, I have not seen it, well, I'm going to interpret offshore to mean outside of the U.S. and not employees of the company. So in an investigations, because you're looking for the needles in the haystack as opposed to the whole haystack, I've not seen a significant use of offshore review resources.
In litigation?
In litigation, it's still, it's not huge, and some of the recent unrest in the parts of the world that had those resources have caused it to diminish, but I'm probably seeing offshore review in litigation in maybe 1% of the cases we work on.
Let's talk about data privacy and some of the issues that are raised there with respect to capturing data and storing and accessing and so forth. Deanna, you were talking about some of the challenges that are posed by storing data up in the cloud. How are you handling this on a global level? I mean, the challenges of data. It's come up a couple times in the conversation so far, but it really is a separate and very large issue.
It is. It's funny because at Siemens, for example, we, in the compliance function, we're really focused on anti-corruption and antitrust. And that was the scope of our responsibilities. And I've just heard in the last couple of months that Siemens has moved its data privacy, data protection team under the compliance function, because it's obviously that intertwined with what we do. And I was surprised because in my role at VMware, I do manage privacy as well. And I'm one of the few compliance people in the Valley that I know that has that type of scope. So it is definitely something that we take very seriously. We generally come up with a grid in terms of, we break every country down. We do this for all of our compliance issues, and we break every country down by its privacy pain points, if you will. And then our investigators have that. That's their Bible. And then obviously I have 3 privacy counsel that work under me that also advise our investigations team as to what they can and cannot do from a privacy perspective.
From a mechanics standpoint on that, then, of course, on the investigations we work on, we're left dealing with, okay, you've resolved it internally, but the data's still sitting in France. Now what? And I have not seen yet a one-size-fits-all approach. I don't think it exists.
But the company should have data transfer agreements intercompany that should enable that.
That's right. And so, although I think you might be surprised at the number who don't.
No, I'm not surprised.
And in those instances, you're left looking for a workaround. And we've come up with, or in collaboration with outside counsel, come up with some approaches to potentially transfer that data to another EU member country that is a little more amenable to getting a team on the ground to actually work with that data. But I have not found a good one-size-fits-all approach for that.
And now this whole area is about to be upset by the new EU proposals, so that even if you have all of these intercompany agreements, that may not be sufficient to meet the safe harbor provisions. So
No,
life is going to get more complicated yet.
Yeah, I mean, I think the trend that a lot of companies, at least that I hear, are looking into are binding corporate rules, which will strengthen your position both on your contracting side with your customers as well as what you can do internally with data. It is a great process to go through if you have the stomach for it, and I think it's something that helps the company in the end in all areas.
Let me ask Lynn and Joe and Troy, you might have a comment on this one too, that as we get into data privacy, it is influenced in many respects by the nature of the industry of the client. I mean, for example, it's a financial institution or a healthcare provider and so forth, there are special rules there. How have you dealt with that in your practices? Have you had financial institutions or?
I just throw up my hands. I really do. This issue's come up for me mostly in the FCPA area, and it's been a privacy issue arising like the laws you were talking about. And my usual advice is I'm not an expert on the law of Germany, right? And usually my clients have in-house expertise that they can call on, but in some instances, we've hired outside counsel in the foreign country to advise the company on its rights to collect data and on the employee's individual privacy rights. So typically, I've used either an in-house or an external resource in the jurisdiction to help me manage that problem.
And I think when you're exporting for any place in Europe, particularly, as we said, France and Germany, you have to employ local counsel, because most recently there was a case in France where the lawyer who exported the documents was criminally sanctioned and fined, went up on appeal and lost, and he remained criminally sanctioned and fined because what he was transferring, they believed, contained privacy-protected material from an individual employee.
And even domestically, and I think this may have been a little bit of what you were getting at under HIPAA, SOX. I mean, HIPAA's meddlesome. There's no two ways
Especially
about
now.
it. That's right. And it's nettlesome not just from a substantive point of view, but even from a mechanical point of view, from a service provider end of how do we segregate personally identifying information? How do we segregate protected health information from substantively relevant documents? And that goes all the way down to the type of servers we have, the type of encryption we use, the how our employees access data. I mean, that's one of the big parts of HIPAA. And so you have to work with a trusted partner that is thinking of those things, so that if you're working with financial information, if you're working with healthcare information, that you have somebody who's aware of the pitfalls there and has already navigated through those.
Well, this also arises with classified information. So the investigation I mentioned, where I've got the 250 custodians, some of them have security clearances, and this is a defense contractor, and there's a lot of classified documents in the universe. And so we are implementing procedures to ensure that the classified documents are not collected. If inadvertently some of them end up in the collection, which shouldn't happen, but if the custodian took a classified document and put it on his or her individual computer, now it's going to be collected, so we need a process to identify and segregate those. Because one of my rules when I conduct an investigation is to ensure that if someone goes to jail, it's not me.
That's very comforting. For the rest of us.
I just lost the business of everyone I know.
Well, we've talked about trends, we've talked about challenges, and we've covered best practices. So let me ask each of you now to think about what are the takeaways that you'd like to leave us with, both people here in the room, as well as people who might be listening to this program in its recorded form, what are some of the advice that you'd provide to them about how to fashion the collection and review programs in an internal investigation? Joe, I'll start with you, and then we'll move down the panel here.
I guess I've made a few comments, some of them addressing this point, but I think the key thing is plan. You got to have a written plan in place, who you're going to collect from, what are your collection methodologies. You don't want to be figuring out on the fly. And you should get a budget. If you're going to bring out outside counsel, ask them for a budget. If you're going to bring in a data consultant or a forensic audit firm or a computer forensics firm, ask them for a budget going in, and make clear to them that if the budget changes at any time because the scope of the investigation broadens or changes, that they're going to commit to get you a revised budget. That, I think, is an effective way of both controlling your costs. Oh, and timelines. Ask for deadlines. You want it done by X date. If that affects the budget, tell me now.
Good, thanks. Deanna?
My recommendation, at least from what I've learned, is to bifurcate the allegations as much as you can. So you've got your serious, your high value, if you've got anything involving FCPA, antitrust, any major regulatory red flag, that automatically goes outside. There's no playing with that inside. And the internal investigations should really be handled, based on their type of severity, the severity and the nature of them, in a process where you've got the fairly low value, minimal touch type activities you can put through a certain process that's low cost and low touch, and then the higher, medium to high value ones, obviously you spend more time and effort on too. Because if you don't have that sort of organizational chart, you don't have that process flow down, at least in your head, you could end up going off the rails pretty fast.
I would just add to that, as you categorize the types of allegations you're getting, if you do get allegations against your senior officers, that's another one where you want to hire outside counsel. You don't want to touch that one.
Hard to investigate your boss.
Yeah.
I look at what Joe said, planning, and also negotiating, what I had said earlier, trying to work with your opponents, limit the specter of what you have to collect, find an effective way to do that through advanced planning, and really coming up with a solid directive of who's going to collect what needs to be collected, and if possible, agree, like I said, with your opponent on different types of ways or methodology of searching, so that when you produce it, there's an agreement to what was produced. So if something isn't there or comes up later, you've covered yourself.
Yeah, good thoughts. Troy, you want to give us your takeaway, and that we'll wrap it up?
You bet. Two things. One, having a repeatable process, and that takes into account the different types of investigations and the categories of those investigations, whether you categorize them by severity or by type. Having a repeatable process that addresses each of those different types that's documented, that's planned out, will certainly ease things on your end. The other is having a trusted partner that understands your approach to investigations, so that when they reach that threshold of needing to work with somebody, that partner already knows what your approach is, what your negotiating stance is, and how you're going to attack collection and review.
And just to add to that point, I would say the process is so important to also document. And for example, what I would suggest in some cases is to have a documented process that you can actually talk about internally within the company, that you can post on your intranet, that so people understand what the investigation process consists of, and also about a responsibility to inform and to communicate on a need-to-know basis. The other part of Dodd-Frank, which we didn't touch on, is retaliation. So if your investigations have a wide reach internally and you're using too many internal resources and people are chatting, then you've got a retaliation claim coming in your next allegation. So that's a very serious issue.
That's a good point, an ominous one to end on. Well, let me ask you, please, to join me in thanking the panel today.